We are in a climate, unfortunately, where so many people are becoming immersed in a government investigation, and many of them have no idea how to respond. Welcome, everyone. I'm Justin Paperny, and I'm here with my business partner, Michael Santos. And I want to dive right in, Michael, talking about, in this case, PPP fraud and how government investigations can begin. So welcome, and I look forward to hearing from you. How does a PPP investigation begin?
Really, all government investigations are something that people should be thinking about, and they begin in any number of ways. For example, the bank is incentivized to be looking for transactions that may arouse suspicion or may be fraudulent. And those banks, a lot of their internal policies will require somebody that if they see something suspicious. For example, a loan came in on a PPP fraud for $1 million and out went a purchase of a new Bentley, a new Rolls Royce, or let's just say it was something a little less flamboyant, where the owner of the business just took a distribution when he should not have been taking a distribution, when it would have been out of the ordinary. These kinds of events can trigger a government investigation, and then a series of events can happen behind the scenes before anyone knows that that person is a target of an investigation. But the more a person knows, the more a person can start preparing for the best possible outcome.
Michael, what steps could a person take at the start of a PPP investigation?
In all instances, a person helps himself when he comes forward before an investigation begins. Because if he comes forward before an investigation begins, he may be able to get some type of a plea agreement that is a pre-indictment plea agreement. Perhaps that individual can qualify for a deferred prosecution or even a non-prosecution agreement. And every case is different. But the first step that somebody should do is really think, am I vulnerable? What were the rules of the PPP loan program? How did I use funds? Did I deploy funds that are in accordance with the PPP loan documents? The government made so much money available that a lot of honest people took those funds without fully understanding that I might not be able to take a distribution from my company, or I may have to use the funds only for very specific things, or may believe that because I have money in another account, I'm going to say that these funds were my funds and not government funds. Well, the more somebody learns about this program and how people are getting prosecuted, the more people can realize, whoa, maybe I am vulnerable. And in some cases, it may make a lot of sense to pay the PPP loan back before there is an investigation, or to reach out to counsel and see if you can get a pre-indictment agreement. And I know that you have a lot of experience with that, Justin. Perhaps you could talk about some of the people with whom our team has worked that found themselves targeted for a criminal investigation, are now standing up for count in federal prison.
What I know is defendants are going to get the best outcome, or the initial steps, if they speak openly and honestly with people they retain and work with. It's easy as a defendant to focus on the good things you do and perhaps live in denial or evade the truth. So you spoke of a client of ours, Casey Crowther, a business owner in Fort Myers, Florida, indicted, unfortunately, for PPP fraud. Actually went to trial, and at his sentencing, the government asked for 12 years, was sentenced to 37 months in prison. If you were to speak with Casey, in fact, our team produced a case study about his case. Part of the reason his sentence was so much shorter than the government wanted was because of the decisions he made as soon as he learned that he was a target. And rather than run from the truth, he said, I may not agree with everything, but I'm going to take proactive steps to prepare. And that includes speaking openly and honestly with everyone that you retain. So that takes us to our third question as we cover PPP and federal investigations. As a basic outline, what should a person expect to follow from a PPP investigation?
Well, any type of government investigation really begins in secret, where authorities, whether it's the Federal Bureau of Investigations or perhaps the Department, the Postal Service, any number of people can start an investigation. That investigation will follow when they go it turns it into a criminal matter when they start working with prosecutors. The prosecutors then will convene a grand jury. And it's important to understand what a grand jury is. It's just a body of citizens that will sit in a room where a prosecutor will present evidence, and that evidence is designed to do one thing, to get an indictment. or to bring a criminal charge. So the prosecutor will be asking the members of the grand jury, again, who are those members of the grand jury? They're frequently teachers, they're nurses, they're firefighters, they're people who may have somewhat of a cynical perspective of entrepreneurs and business people who are taking large sums of money from the government and then using it using those funds in an alleged inappropriate way. So the more you understand, hey, who's this body of people? What are they going to be? What are the prosecutors going to feed them? And then also remember, there's not going to be any defense there. There's not going to be anybody giving an alternative version of events. So the prosecutor really completely controls the narrative. There's no rebuttal. There's no explanation. There's just, here are the facts, and then they're going to ask for an indictment. Or the prosecutor may choose to reach out to the subject or the target of the investigation and try to get a pre-indictment pleading. They may reach out to, if the defendant or the person is represented by counsel, they may invite a proffer session where the government will say, hey, this is what we know, and we want you to come and sit with us, listen to our case, and tell us why we shouldn't charge you with a criminal conspiracy or a crime. And you get to listen, and you get to try to make a case. Then an indictment or a charge could follow, whether it's through an indictment, a criminal information, or a criminal complaint. The next step will be a plea hearing. The next step will be, after the plea hearing, assuming there's going to be a plea agreement, there's going to be a change of plea from not guilty to guilty. Then there's going to be a pre-sentence investigation and a report and preparing for sentencing and getting ready for prison, and a whole series of events that every individual should understand to position themselves for the best possible outcome.
And one thing I'll add to everything Michael just said as he walked through a plea hearing and a PSR interview and a sentencing. You can expect this to take some time potentially to play out. It wouldn't be uncommon if it's 8 months, 12 months, or 2 years. So it's essential that during this time you're living productively and taking proactive steps to prepare possibly for the inevitable of a sentencing hearing and potentially serving time in prison. But I think it's important that we disclose this could take some time to play out. And the waiting can be difficult, but it's key to be productive during this window. Michael, in our continuing series are questions on PPP, loan fraud, and federal investigations. Let's transition to, what if a person didn't know how to use funds from a PPP loan?
Well, sadly, in the United States, ignorance of the law is not an excuse. If you've broken the law, sometimes the prosecutors are going to bring a case. Now, to the extent that a person has launched an effective mitigation strategy, they may be able to meet with the prosecutor or the government investigators and try and, through counsel, negotiate a pre-indictment charge. The problem is that once a person gets charged, the only way to dismiss that charge is to get permission from a federal judge. So it's a little bit harder. The earlier somebody learns and understands, hey, I'm vulnerable to a criminal charge, I better take some action steps to mitigate this strategy, because if I've broken the law, my ignorance of the law is not going to excuse me, particularly if I've used those funds in a manner that a prosecutor or a judge would consider somewhat of an egregious manner, such as I took PPP funds and use those funds for some type of a purchase that the government would say is clearly extravagant. Buying a new boat, buying a new luxury home, using the money to go gambling. These types of expenses are not going to work in favor of the individual because the government may say there was a predisposition for fraud. So it's important to think about all of these factors when creating a mitigation strategy and then choosing the best appropriate solution to this potential problem. But ignorance of the law is not going to lessen the likelihood of a criminal proceeding.
As we continue in our series, or these questions on PPP loan fraud, I'd like to ask, what record would investigators use to build a case on a PPP loan fraud case?
The reality on white-collar crime is they are really easy for government officials to prove because there is an abundance of records. There are the exact loan application that somebody put forward. And the person has to check a series of boxes that they understand what are the proceeds of these loans, what are the allowable or permissible uses of these funds. Sadly, a lot of business owners look at this as pretty simple money, access to money, and sometimes they make a case where they read this description that says, well, I'm only going to have to pay it back at 1% a year, and they think it's just cheap money. But the reality is, what was the purpose of the PPP loan program? It was to really save people that have had businesses disrupted because of a pandemic, and it's to provide payroll protection for the workers. If the owner of the business absconds with those funds or uses those funds inappropriately, it's going to result in a potential problem. So to the extent an individual understands, hey, there's a lot of ways that the government can prove this case. They can see, number one, the evidence of the loan application I submitted. Number two, they can see when did those funds get deposited into the account. Number three, the bank will provide them with records of how those funds were dispersed. Were those funds dispersed in violation of the terms of the loan? Red line, time for investigations to begin. Sadly, people don't always understand that if they've taken those funds, they have limitations on how they can use any other funds in their business.
And to close this point, you can expect potentially the government to rely on resources or records from a defendant in the case who may be cooperating. That happened recently. Someone reached out to our team, couldn't believe that he had been turned in by his accountant, who apparently had encouraged, I think, damn near 100 people to fraudulently fill out some of these applications to get this loan. And the accountant was rewarded by getting a small little extra 5% bonus when the money came due. The government got to the accountant first, and the first thing he said was, what can I do to try to keep myself out of prison? And he gave the records and names of 100 clients. This is the cynicism that comes with becoming a part of a government investigation.
And there are a number of ways that the investigation can begin, such as some of the employees can turn you in. There's just so many ways the thing can start. There's always going to be a record, and that record can expose people to potential problems.
As we continue our discussion on federal sentencing for PPP loan fraud, I want to turn to question number 6. How will a person know if authorities have launched a PPP loan fraud investigation?
A lot of times people will not learn about an investigation until it's too late, when authorities are banging down the door and coming inside. If somebody is a little bit more fortunate, they may receive a subpoena, or their accountant may receive a subpoena for bank records. If that happens, there's a good chance that investigators are already looking at an individual. If you have a good relationship with the bank and the bank notifies you, we have been asked to provide financial records to an investigative body. That's another way that somebody knows they're a target of an investigation. But in more cases than not, the person is going to learn about an investigation when authorities come after them. Now, if a person has taken preemptive steps to try and settle a case before an investigation has really begun, the defense attorney, for example, may try to reach out to the U.S. Attorney's Office in that particular jurisdiction and try to coordinate a proffer session where the person might come forward and talk with the government about his position. Sometimes the government may ask an individual or a defense attorney to bring the client in if the government is really thinking, hey, we may have a case, we may not have a case, let us present what our evidence shows why we're inclined to indict, and we're going to give you the opportunity to convince us not to indict. These are the steps that might take place for somebody who is fortunate enough to qualify for a deferred prosecution agreement or a non-prosecution agreement. Instruments that aren't always available for the PPP loan fraud issue, but every individual is different. Every individual should work to learn as much as possible, as soon as possible.
I want to touch on one point. A client of ours indicted for a PPP fraud in Georgia asked us, and you gave a profound answer, so I'm hoping you can touch on it here. He wanted to know, despite being a law-abiding citizen for 40 years, contributing to his community, being a coach and a good father, employing a lot of people, he didn't understand why the government would spend resources knocking and banging down his door at 6 a.m. with helicopters and guns. Can you help everyone watching understand why the government would do that?
Well, I think it's important to remember the stakeholders of any investigation. You may see yourself as a law-abiding citizen, as a father, as a coach, as a husband, as a churchgoer, or a man of faith. Those are the ways that you see yourself. But how do the other side see themselves? And what are the objectives of the people on the other side? If it's a prosecutor, a lot of times that prosecutor defines success very differently from you. They are seeing you not as a human being so much as a defendant. So they have effectively dehumanized you. And their success, their career trajectory is going to advance based upon the number of convictions they get. And if you're a trophy, well, they can score a lot of points with a very high-profile arrest that includes that breaking down the door, helicopters, news reporters being brought on the scene, because that's going to be a headline, and that headline later may appear on a prosecutor's resume when that person's trying to position himself for a job with a white glove law firm. So trophies really need to be thinking about, hey, I know who I am and I know how I see myself, but that's not relevant. How do the stakeholders see me, and what can I do in anticipation of the way that they see me?
As we continue on federal sentencing for PPP loan fraud, we're going to talk about lawyers. Many people who get into trouble have, in some cases, never even retained a lawyer. So, Michael, question number 7. What kind of lawyer would someone need for a PPP loan fraud investigation?
That's a great question, and you're exactly right. A lot of people who consider themselves honest citizens, employers, business owners, never contemplate the possibility of a criminal indictment against them. But when that happens, they need to realize that a federal sentencing hearing is likely going to follow. So they should be looking for an attorney who specializes in federal sentencing and mitigation strategies. Sadly, a lot of people who have no experience might hire their brother's cousin's girlfriend who went to law school and practices real estate law or wills and trust. But that person is not going to have the depth and breadth of experience of federal sentencing and mitigation strategies, and so that person may be at a real disadvantage. Sadly, when somebody faces a criminal charge for a white-collar crime, that person has to begin preparing for sentencing really soon, and they need the best advisors to help them make decisions going forward.
Michael, oftentimes people get a bit of sticker shock. I know I did when they hear the cost of retaining a law firm. Some are required or forced to retain a federal public defender, and I think there's this mistaken belief out there that federal public defenders may not be capable or great. Can you touch on the effectiveness of federal public defenders? Our team has had scores of clients have great outcomes working with federal public defenders, so touch on that if you would.
We definitely have an enormous amount of respect for attorneys that work for the Federal Defender's Office. In fact, people who work for the Federal Defender's Office are really true believers in the system of justice. They've really trained extensively. They generally graduated at the top of their law school class. They go to the Federal Defender's Office either because they want to make a difference in the system, or they want to get even more training before they transition into their own private practice. But the federal defenders have extensive training in the federal sentencing guidelines, which is really important because they can draw upon cases from across the country. They can see mitigation strategies that are working. And the good news for somebody who hires or works with a federal defender is they get to preserve resources that they can use on their own to develop their own mitigation strategies. Sadly, a criminal indictment in the federal system is going to result in rather expensive expenditures for both legal counsel and preparing the family and everything else. So we really encourage people to use a federal defender if they're eligible, and to learn about what steps they can take to become eligible, and then they're just able to make more informed decisions.
As we continue talking about federal sentencing for PPP loan fraud, going to transition into how to reduce time. And before I ask this question, I'll note it is not uncommon for our team to receive a call from a defendant who is just sentenced, leave the courtroom, begin Googling how to get a shorter prison term. In our work, in our videos, our blogs, our books, something may come up and they'll say, what can I do to reduce the sentence? And oftentimes, a lot of the work they could have done has passed because they've been sentenced. So this question, Michael, the ninth question, for those who want to prepare, what steps could someone take to reduce time in prison for a PPP loan fraud investigation?
I think you're exactly right that the person really just needs to begin preparing really early. Like even hopefully before they have been charged. But if the person has been charged, the person needs to understand mitigation strategies, and there are different steps at different stages. One stage is going to be pre-charge. One stage is going to be getting ready for the pre-sentence investigation. One stage is going to be before the sentencing hearing. One stage is going to be while the person is in prison. One stage is going to be during the supervised release, or how do I get a higher level of liberty while I'm in a halfway house or on home confinement. One stage may be after the person has completed the halfway house portion, is trying to get early termination of supervised release. There's just so many stages that a person needs to begin preparing that it all starts with really just doing research. What does it look like, a mitigation strategy? What do I need to know about sentence reform legislation? What do I need to know about the First Step Act, the Second Chance Act, and efforts to position myself for compassionate release? All of this is really predicated, all of those different release mechanisms are predicated on early preparation, and nobody should work harder than the individual to begin working for an earlier release date. Don't rely on a defense attorney. Learn to become a great self-advocate.
And one thing I'll say, a client of ours, Brandon Coluccia, when he reached out to our team, said, I've been reviewing your work for months. I was advised that it's too early to begin preparing. And I said, it wasn't too early to get indicted, to read your name all over the internet as someone who's breaking the law. It wasn't too early to give a six-figure check to retain a lawyer. And he said, you're right. Everyone else is putting wheels in motion. I think it's time that I also put wheels in motion. It is never too early to begin preparing and making sure you're getting the absolute best and right information for you.
And you might tell your viewers, Justin, what was the outcome for Brandon as a result of those preparations?
Through Brandon's hard work, he went from a potential sanction of 15 to 20 years in prison to an ultimate sentence of 37 months in prison, worked incredibly hard in prison to continue to build a new record, and as a result of that hard work, was released in just over 10 months, went to the halfway house in Florida for just a few days, and they immediately transitioned him to home confinement. It's the benefit of taking action early, of preparing, holding people that you hire accountable, and working as best you can each and every day to try to change the outcome. How would the federal sentencing guidelines apply to a PPP loan fraud case?
That's a great question, and people should definitely spend some time on the Prison Professor's website to understand a little bit more about the sentencing guidelines and what steps a person can take to maneuver their way to the lowest possible sentence. Basically, the guidelines are a grid. There's a vertical scale with a series of points from 0 to like 42 or 43, and that vertical scale effectively measures every federal crime, the statute itself. And then there's a horizontal line that measures a person's criminal history. And it's where those 2 points intersect that the guidelines will provide a range. And that range may be anywhere from, say, 37 to 48 months or something along those lines. And in that window, what the person wants to do, first of all, is get the lowest possibility of the range, but hopefully move lower on the vertical scale so the person is not facing as much time. Now, what's important to realize about the federal sentencing guidelines is they are only advisory. They're not mandatory. That means a person can really work to help a judge see why he is worthy of leniency or mercy at sentencing. The earlier a person begins thinking about that process, the better position that individual is going to be to request something lower, or to help his attorney ask for something lower. It's our belief that every individual is his own best advocate, and the sooner a person starts preparing, the better off that individual becomes to get a lower sentence.
Michael, forgive me if I recite this incorrectly. We have an interview with Judge Boo on our YouTube channels and websites where he discusses that the guidelines are just a grid, numbers on a page, and it doesn't necessarily reflect the humanity or background of the defendant. Again, if I got it a little bit wrong, forgive me. But can you just quickly touch on that interview with Judge Boo and those, mentioning of the guidelines?
Judge Boo was a great friend of ours in spending time to talk about what steps a person can take to move the needle at the sentencing hearing. And at the end of the day, the judge said, I am way more interested in the individual before me than what the attorney says. He says he knows what the attorney is going to argue. Doesn't matter what person is before him. If a person hires a defense attorney, that defense attorney is a paid advocate. What the judge wants to know is about you. Why are you worthy of a lower sentence? And to the extent that you invest time to learn about how you're going to differentiate, how can you differentiate yourself from other people that go before a sentencing hearing, you're really investing in yourself. And we would encourage you to watch those videos with Judge Boo, Judge Bennett, to read our articles on preparing for sentencing so that you can get the best possible outcome and get your confidence back, get back to society as soon as you possibly can.
Last I'll say on that topic, Judge Benita Pearson, a federal judge in Ohio, I heard her say on stage it is the defendant's obligation or duty to convey to a judge in her every fracture or every detail of their life. And she said only a defendant can really do that work, so take that to heart. Where can someone get guidance on steps to take for a potential PPP loan fraud case?
I'm glad you asked that, and I do hope that people are looking for guidance from credible sources. We have more than 1,000 videos right here on the Prison Professor's YouTube channel, another 500 or so on the White Collar Advice channel. We've got I don't know how many countless articles about people, how people can prepare for mitigation strategies. Really, the more a person learns about what's happened to others, the more effective that individual is going to be in engineering a strategy that will help that person. There are no cookie cutter, boilerplate strategies. Every human being has a personal story. We encourage that person to learn how to become an effective self-advocate, how to help the defense attorney advocate for you, and really just understand the system. But we offer an abundance of free information. We would encourage you to read more anywhere you can find good information, assess whether you found the person to be credible, and then make decisions that are going to be based on your personal circumstances.
And the last thing I'll add is make sure you're getting advice from people that are telling you the truth rather than telling you what you want to hear, and that requires you to speak openly and honestly and to think about some of the choices that led you into this predicament. So surround yourself with truth tellers. Those are the best people to give you guidance. I'd love for you to offer some final thoughts and insights for people going through this. What are some strategies you have to ensure they're living productively and emerging from this experience as strongly as possible?
Sadly, a criminal indictment is really a disruptive event, not only for the individual, but for everybody the individual loves and who loves the person. It's really a big problem. But the solution to any problem, it requires a strategy. And that strategy is the same strategy that people use to develop a business, that put them in the position of being able to apply for a PPP loan, right? When we start a business, we're trying to solve a problem. And to solve any problem, we got to start with the best possible outcome. How do I define success? And I don't know, if there's a million people, there's a million stories. Everybody has his or her own story. To the extent that an individual could say, where am I and where am I going to be in the future? What does that look like? I can start engineering a strategy that will take me from here to there. If I don't understand all the steps in the middle, I have a very hard time of getting there. I might go in this direction with one attorney one day. I might go in this direction of deciding, hey, I'm going to go to trial this day. I might go to this direction and say I'm going to pursue a mitigation strategy this day, right? The more a person engineers, the more a person can cut through all of that and make a straight line toward the best possible outcome. So we encourage people to define success given their personal circumstances. Second, we encourage people to create a plan. Third, we encourage people to put priorities in place because that plan has different steps. And the things I do here are going to put me in an algorithm of what I'm going to get here, or a step that's going to relate an opportunity that I can get here. And then we encourage people to develop tools, tactics, and resources that will help advance their possibilities for the best outcome, and then execute that strategy every single day. Those are the lessons that empowered me through 26 years in prison. They're lessons that I learned from leaders, and they are lessons that I would encourage every individual to follow if they find themselves in the unfortunate situation of a criminal indictment. What we will say is, regardless of what's happening right now, you can start making decisions to influence a better outcome, and we encourage you to do so.
Michael and I, our whole team, would like to thank all of you for taking the time to watch these videos, and we encourage you to keep learning, to keep going. Subscribe to our channels, White Collar Advice, Prison Professors. Go to our websites and digest that information, and just don't read it. Implement everything that we teach you, and encourage you to learn more about the ways that our team is helping people traverse this system, our whole ecosystem, from our nonprofit Prison Professors Charitable Corporation that's helping people, training people in prison, emerging successfully to the job market, helping people be productive while in prison, and everything that accompanies a government investigation. We want to help you. Our team wants you to be successful. And again, we're very grateful you've taken the time to watch this video and let our team help guide and teach you. We know your time is valuable. So thank you again for checking out our work.